It is 6:45 p.m. in a quiet federal courtroom, and you are about to tell the United States government to turn planes around in mid-air. Not tomorrow, not after briefing. Now. Because if those men leave U.S. custody tonight, the law may never catch up. You are James E. Boasberg, Chief Judge of the U.S. District Court for the District of Columbia. You have handled homicide cases. You have served on the Foreign Intelligence Surveillance Court. You are not new to claims of urgency, secrecy, or national security. But this is different, faster. The White House has just reached back to 1798 for the Alien Enemies Act, and by the time the public even sees the proclamation, the machinery may already be moving. It is signed on March 14, 2025. The public does not see it until March 15 at 3:53 p.m. Eastern. That detail matters, because by the time lawyers can challenge it, the clock is already bleeding out. The proclamation says Venezuelan nationals age 14 and older who are alleged members of Tren de Aragua can be removed under a wartime law written when John Adams is president. The administration's theory is explosive. This gang amounts to an invasion or predatory incursion, enough to trigger emergency power under the Alien Enemies Act of 1798. You read that and immediately see the real question. Not whether gangs are dangerous, not whether the president can act quickly, but whether an old war statute is being stretched so far that speed itself becomes the strategy. Move fast enough and the courts become spectators. Then the emergency challenge lands in front of you. The plaintiffs warn that deportation flights may already be underway. Men may be on buses, on runways, may be already strapped into airplane seats. If they are transferred abroad, especially into Salvadoran custody, any right to challenge their removal may become meaningless in practice. That is the word that matters now. Irreparable. In federal court, harm is irreparable when a later ruling cannot truly undo it. So you sit in the polished stillness of a DC courtroom, and the room feels almost insultingly calm. Lawyers in suits, paper, microphones, quiet voices. But beneath that silence, a race is on. At 5:22 p.m., you pause the hearing and direct the government to find out whether removals under the proclamation are already happening. Where are the planes? The hearing stops. Everyone waits. Around 6 p.m., the government returns with an answer that is barely an answer at all. It has no flight information to report, no flight information. That is when the dilemma sharpens. You are being asked to decide a constitutional emergency while the one fact that matters most, whether human beings are already disappearing beyond the court's reach, is unavailable, undisclosed, or both. And the stakes are not theoretical. The United States has already arranged for El Salvador to take deportees into CSOT, the terrorism confinement center in Tecoluca. Reports say the U.S. agreed to pay $6 million for El Salvador to imprison about 300 alleged Tren de Aragua members for a year. This is not improvisation, it is an operational pipeline. You also know the government side. It says national security is at stake. It says the president's powers over foreign affairs are at their apex. It says Tren de Aragua is dangerous. Maybe some of these men are exactly who the government says they are, but maybe some are not. Later reporting finds that among the 238 Venezuelans sent to El Salvador, about 75% had no identifiable criminal record that CBS News could find. A makeup artist and asylum seeker, André Hernandez Romero, is alleged to be gang-affiliated in part because of crown tattoos his lawyers say reflect a cultural tradition. A barber, a soccer player, men whose files may not match the labels attached to them. And that is the point. The courtroom is where labels are tested before the cage door closes, not after. If you're enjoying this story, hit subscribe so you don't miss what happens next. Because this is the moment the case stops being about paperwork and becomes about whether courts still have brakes, so you act. Around 6:45 p.m., you issue an oral temporary restraining order. It blocks removals under the proclamation for 14 days. It provisionally certifies a class, and then you say the line that will echo far beyond your courtroom. Any plane containing covered individuals that is going to take off or is in the air needs to be returned to the United States. Returned. You make clear the government must ensure the order was complied with immediately. Then, around 7:25 p.m., the written TRO follows. It is narrower than many people later claim. You are not ordering anyone released. You are not halting detention. You are not stopping every deportation under every immigration law. You are drawing a specific line. Do not use this March 15th proclamation to remove these people before a court can examine whether this extraordinary use of emergency power is lawful. That is your job. Preserve the court's ability to decide before the decision becomes useless. But the planes land anyway. By early March 16th, deportees are in El Salvador, at Cot. The giant prison of shaved heads, hard lights, steel bars, and permanent-looking finality. Whatever these men are accused of, this is no longer a line in a brief. It is bodies in foreign custody. And suddenly, you are not just a judge. You are a target. President Trump attacks you publicly and calls for impeachment. Representative Brandon Gill introduces H.R. 270 seeking your removal. In another era, this might have remained an ugly political spat. But then Chief Justice John Roberts does something rare. On March 18, 2025, he issues a public statement. For more than 2 centuries, it has been established that impeachment is not an appropriate response to disagreement concerning a judicial decision. You do not answer in public. Judges usually do not. The institution answers around you, and then on paper you answer with something colder. On April 16, 2025, in a memorandum opinion, you write that the detainees were spirited out of the United States before they could challenge their removability. You describe a hurried removal operation. You conclude that probable cause exists to find the government in criminal contempt. That is not just a legal phrase. It is a constitutional warning. Then comes the sharpest line of all. The Constitution does not tolerate willful disobedience of judicial orders, especially by officials of a coordinate branch who have sworn an oath to uphold it. Notice what this means from your point of view. The danger is bigger than one deportation policy, bigger than one president, bigger than one district judge. If the executive branch can move people onto planes, invoke emergency power, withhold enough facts to run out the clock, and then argue the court arrived too late, then the judiciary is no longer a check. It is scenery. Now the legal story keeps going. On March 26th, the D.C. Circuit leaves your TRO in place by a 2-1 vote. On April 7th, the Supreme Court vacates it on procedural grounds, saying the detainees must proceed through habeas in the proper venue, while still insisting they must receive notice within a reasonable time to seek review. So the court does not simply bless everything the administration did. It changes the route. The core due process concern survives, and that may be the most important thing to understand about this whole episode. From your bench, this is never about open borders or closed borders. It is never about whether presidents can respond to danger. It is about whether urgency erases process, whether a gang can be treated as an invading enemy under an 18th century war statute, whether a courtroom still means anything if the planes are already gone. That is why one ruling from one quiet courtroom turns into a national firestorm, because beneath the politics is a simpler, older fear. In a real constitutional crisis, power does not always crush the law by arguing better. Sometimes it just moves faster. If you enjoyed this, please like, share it with your friends, and subscribe.